Hi everyone, welcome to our group presentation, which is Asic versus Maxwell and ORS 2006, New South Wales Supreme Court, Case 1052. This presentation is based on Corporation Law HA3021, conducted on Holmes Institute, Sydney. Thanks to our lecturer John for providing us this opportunity. We are the group of 5 people presenting this presentation today. Me, myself, Subhas Guru, student ID NBA2003. Accordingly, Anumanandar, EMB 21597, Bisal Chaulagar, EMB 21868, Roshan Parajuli, EMB 21472, Sabrin Nupane, EMB 21473. Now I'd like to start the presentation with introduction. Okay, our presentation highlights policies regarding the issues of business entities within Australia, and the overviews of the case and the issues of the case and the decision, all the decision taken by the judges with justification and the application of the verdicts given by the judges and the conclusion, which will be like explaining by my fellow mates on the further presentation. Thank you.
Thank you. My name is Anumanandar and my student ID is EMB 21597. Today I'm going to talk about issue of the Asic versus Maxwell case study. The information contract produced by the Maxwell was not regarded as the disclosure documents as per the Corporation Act, whereas the restrictions for advertisements were not being followed. Maxwell claimed that information contract is enough for the disclosure documents. However, the investors are not satisfied with the information memorandum. They need to have the disclosure document for their safety. Now, things that were missing in the advertisement as per law are the identity of the securities and the issuer, statement of the offer or the securities, statement of the investor, the advertisement that is published by the company for collecting the funds for the building project need to have some essential points, whereas the statement of the offers and securities are missing along the statement of the investors. The advertisements so not have identities of the securities and the issuer. Now the rule of the report gonna be discussed by Bisal.
Hi, I'm Vishal Chaunagai, AMB 21868. Today I'm going to discuss on the rule of the report, and it includes the section. The section involves, as per the section 734 part 6, advertisements should include the offer of the securities that can be accompanied by the disclosure documents. It has been observed that the defendant has breached the laws as no offers of the securities are being accompanied with the disclosure document. As per the section 734 part 7, advertisement for publication need to have the report of the general meeting with the body. Maxwell have not included reports for the general meetings that can be done with the investor. This has also led to an issue. Corporation Act 2001. Section 734 part 5A states that permission for the advertisement is required before lodgement of a disclosure agreement document. And 734 part 5B, for the advertisement publishment includes the statement that identifies the offer for the securities to the customer. In the same way, Maxwell has breached the section and laws by the providing incomplete information in the advertisement. This has misled the investor and they are scared of their securities. In the same way, as per the section 708 part 6, part 10 and part 11, sending of draft to the person covered by a sophisticated investor is not being regarded as the contravention of the pre-lodgement of the advertisement and its restriction. It has been observed that these laws are also not be met by the Maxwell. The advertisement do not include any of the clauses that is mentioned in this section. Well, as per the 734 part 3, attracting the new customer for product is not subjected to the fundraising if the advertising is restricted in an organization. This particular section states that advertisements are restricted in organization in order to control the fundraising. And this is the end of my topic. Now I'd like to call Rosan Parazuli to continue the report. Thank you. Thank you very much.
Thanks, Bisal. So, hello guys, me Rosan Farazuli, student ID EMV21472, explaining the application of the Corporate Act 2001. Corporate Act 2001, Section 180 is applicable for director of the company to sue their powers and duty towards customer. It has been breached by Maxwell by not providing disclosure documenting the advertisement. The advertisement has misled the investor for the funds for developing the various types of project. As per the judge's decision, penalty has been given to Maxwell, finding him in the guilty position. The case verdict are as follows. In the case of Dempsey Resources Pty Limited versus Continental Gold Limited 2009, similar situation has been observed. The same verdict has been given by judges. The consent section can be applied to the case in which the misleading is done by the company to their own customers. The application of the case verdict of Asic versus Maxwell and ORS 2006 and SWSC 105 to two others companies. The advertisement will be taken care by the another companies in order to avoid issues. Company will have consent to meet all the requirement of the section that were based in the case of Maxwell. Proper statement that identifies the offers and securities needs to be maintained in order to ensure securities in the company. Through advertisement, all the information including the disclosure documents should be incorporated in the advertisements. And now the application of the Corporation Act, the Hotel Victoria Pty Limited, Crown Melbourne Limited 2015 is mentioned below. Investors are observed to be insecure due to lack of proper disclosure statement. The contract do not include proper terms for the investment to ensure security. In the case application of Corporation Act, Cosmopolitan Hotel Victoria Pty Limited versus Crown Melbourne Ltd 2015, the investor denies to invest the money due to the proper contract terms in the advertisement. Now the recommendation for the other companies based in the concerned case are as follows. The higher people so that advertise department could be monitored properly. None of the terms based on the section of the Corporation Act should be missed in the published advertisement. Other companies of the Australia could recommend with the proper process of designing an advertisement. This will help in avoiding any kind of legal issue for the company. Legal advisors should be contacted for such type of advertisement in order to avoid issues. The corporate governance of the companies will be improved and reformulated based on the verdict of this particular case. Now, I'd like to call Sabin Nupani for the further explanation. Thank you.
Hi, my name is Sabin Nupani and my student ID is EMB21473. Now I'm going to discuss about the conclusion of our report. Based on the above discussion, that it can be concluded that Maxwell has breached the duty and responsibility of directors as per section 180. The advertisement has been published by the company that misled many of the investors to ensure their security through the investments. Based on the law breached by Maxwell, advertising the firm's loan, the court has given verdict of penalty on the basis of the section 1317E. Dishonesty in the business is shown by directors of the company, which can be misleading to the customers and facility that are given by the company. The directors must be honest about their duties and responsibility. This will help the avoiding legal issues and related to the advertisement. Penalty can be prevented without publishing the untrue and misleading advertisement. So the directors must be responsible and perform their duty accordingly. Thus, it can be concluded that all the directors needs to be honest and should follow the Corporation Act 2001. The penalty given to Maxwell, which could have been prevented from giving to him if he had been honest and followed his duties. Thus, I would like to recommend that all the directors should follow the criteria that are mentioned in the Corporation Act 2001 and comply with the Act and avoid misleading information and advertisements to any of the customer and any investor. Thus, before publishing any kind of advertisements, a lawyer should be consulted so that in case of any disclosure documents, if it's missing, then it can be included with the help of the legal advisor or the advice of the lawyer. So this is all about the report, and thank you so much. Thank you.